Good day, ladies and gentlemen. If you want to gather around a little closer, make sure you can hear me.
I'm actually at they/them.
Not that close, everybody. Come on.
Come on, guys. Not to crowd
maybe
them.
not.
Let's
not
go.
not that close, please.
Okay, sorry.
All right. Thank you, ladies and gentlemen, and non-binary individuals of San Andreas. My name is Associate Justice Judith Mason. Thank you all for being here today on this lovely Sunday. At this point in time, I would like to introduce the Chief Justice of the San Andreas Judicial Branch, Colt Daniels.
That entrance was smooth.
Hello, ladies and gentlemen. Hello. Thank you, Miss Mason. All right. Hello, ladies and gentlemen. Thank you all for being here today. I'd like to start off by thanking the members of the Department of Corrections, the Los Santos Police Department, and Weazel Entertainment News Network for being here and helping to ensure this press conference runs smoothly and then the information can reach many citizens of our great state.
Excuse me, boy.
With the recent appointment of San Andreas' head prosecutor, Attorney General Hugh R. Allgood, the San Andreas Judicial Branch would like to begin rolling out additional responsibilities for the members of the Prosecution Division in order to more effectively represent the state of San Andreas during criminal cases brought before the court system. For context, the role of a prosecutor in criminal trial is to argue on behalf of the state of San Andreas and must prove beyond a reasonable doubt that the defendant engaged in conduct that was in violation of the state of San Andreas' penal code. As such, prosecuting attorneys in the state have the authority to work closely with the appropriate law enforcement agencies in order to build up their case against the defendant in criminal court. This would apply in situations such as participating in legal questioning of a suspect to determine if charges can and should be pursued, and for investigatory purposes in conjunction with a law enforcement agency prior to the placing of charges. Furthermore, prosecuting attorneys in the state now have the ability and authorization to open cases against individuals that have not yet been officially charged with a crime by law enforcement, in addition to having the authority to act in conjunction with law enforcement agencies in the pursuit of criminal charges. Following this change, courtroom procedures will largely remain the same. However, preliminary proceedings for cases that come about in this manner will be different. First and foremost, for any case brought to the court by a prosecutor, the Attorney General will need to sign off on what is called a criminal complaint. This complaint is a preliminary charging document submitted by the state alleging that a person has committed a specific offense. Once the Attorney General signs off on a complaint, it will be sent to a judge or justice working in a superior court. If the judge believes that probable cause has been established, they will then file an indictment, which brings us into the second step of the preliminary proceedings. An indictment is filed onto the public docket by a judge presiding over the case. The judge will give the case a docket number, and the indictment will outline who the defendant is and what crimes the state alleges they have committed. Attached to the indictment will be a notice to appear issued by the court, outline a specific time frame in which the defendant must either come to the courthouse for the arraignment or contact the presiding judge to make arrangements. If the defendant fails to do so, the courts will issue a detainer for the defendant. This will notify law enforcement within the state that the defendant is wanted by the court to answer for the crimes alleged against them. Once in custody of law enforcement, they will be brought to the courthouse for the arraignment. This brings us into the third and final stage of the preliminary proceedings. As some of you already know, about 2 weeks ago, we conducted the state's first arraignment for the case of 22 CM0015, the state of San Andreas versus Sofia Falcone. The court found that Ms. Falcone was guilty of 32 charges and sentenced her to life in prison without the possibility for early release or parole. With that being the very first within the state, we were able to iron out any issues that have come to what we believe the best way to host these will be. During an arraignment, the judge, the prosecutor working on the case, and the defendant will be present. The judge will outline the crimes alleged against the defendant and ask the prosecutor what punishment the state is seeking for each charge. The defendant then has 3 choices on how they wish to plead to the alleged crimes. A plea of guilty indicates to the court that the defendant confirms their guilt of the alleged conduct that was in violation of the penal code. If the defendant pleads guilty, The charges and fines will be placed onto the record, and they will begin serving their sentence immediately following the proceedings. A plea of not guilty indicates to the court that the defendant disputes the charges being filed against them. If the defendant pleads not guilty, they will be released pending trial for the crimes alleged. A plea of no contest is similar to that of a guilty plea, but indicates to the court that the defendant accepts the conviction with the exception of avoiding a factual admission of guilt. If the defendant pleads no contest, the charges and fines will similarly be placed onto their record, and they will begin serving their sentence immediately following the proceeding. If the defendant wishes to exercise their right to remain silent during the arraignment, the court will enter a default plea of not guilty on their behalf. If the defendant like stated previously, with a plea of not guilty or no contest, the defendant will be found guilty of their crimes alleged and will be transported to the Department of Corrections to serve their time, effectively ending the case. However, with a plea of not guilty, the defendant will be released pending trial. If a plea of not guilty is entered to the court, a public defender will be assigned to the case, and an order for discovery will be submitted to the docket, opening the case as usual. With the additional authority, the San Andreas Judicial Branch wants to assure that the public, that all of our attorneys, both prosecution and defense acting within the state, have a number of responsibilities and obligations that must be adhered to when conducting their duties. Each one of our attorneys is bound by their oath of office and is required to abide by the Code of Ethics, which outlines the conduct expected of them and prohibits conduct that would violate any laws or regulations as set forth by the San Andreas Judicial Branch. In conclusion, the San Andreas Judicial Branch is affirming the authority of our prosecuting attorneys in their efforts to convict citizens of the state that violate the laws that we all must abide by. At this time, I would like to open it up for questions. Sir, can you turn your phone off,
Please
please?
silence your phone.
Did somebody say they had a question?
Yeah, defund the police.
It's not a question, sir.
It's not a question, it's an answer!
Let Sophia go.
These are statements, guys, not questions.
I have a question.
It's a free country, sir.
Yes.
To your left. Hi. I have a
Hello.
question.
Yes, what is your question?
I like your hair.
Yeah, if someone commits a crime, can they make instantly a court case on that?
If somebody
If they think
is...
that- Go on.
Sorry, what?
Go on, go on.
If somebody is arrested, like usual, we've had this for about a year in this state at this point, they can file a case if they believe the charge is not appropriate for the crimes that they've committed. And that can be found on the government website under the Judicial Branch, under the Superior Court of San Andreas, and they can file a case.
But how about we make it so there's no need to make a fucking government thingy or whatever? How about we just call someone there, we say that we're not guilty, and then with everything that we have,
that is not easily done, sir. We believe we currently have the best solution for this. I see that Cobb has a question. Solomon Cobb? Currently, we have no plans to introduce a jury system. The verdicts are done by a judge, but I can't assure everybody that a judge working on a case, whether that be myself, Associate Justice Mason, Justice Roy Duke Judge, all of our judges working within the Judicial Branch and ones that we do plan to have in the future are
on God?
They're impartial. They'll make sure to call it right down the middle how they see it, and make sure that justice prevails in the state, whichever way the scale weighs.
Nice hat.
On job?
So I do have a question.
Well, I'll answer your question after Cobb's here. Request a different judge. Currently, there isn't an official form to do so, but you can, if you believe the judge on the case is biased, you can request a different judge on the case under certain circumstances. That will not always be granted, as some people might request a judge because they have a problem, or they see the case not going in their favor for a specific reason. But if good reason is given, then they can request a different judge. Judy, do you want to answer Molly's question? I'll let you answer some.
Sure.
All right.
So it will be rather similar. The role of prosecutors initiating charges rather than that of a law enforcement officer is more for situations where perhaps it's, for lack of a better term, a little bit more unclear, or if a case has been building up against the defendant for quite some time, rather than initially arresting the defendant on the spot. Please, sir, if you wouldn't mind putting your clothing back on in front of me, or leave the area. Thank you. Instead of arresting the individual on the spot and placing them into custody.
Oh no, it's the Taco Bell. I have to go.
It's a different way for prosecutors to enforce the laws along with the law enforcement officers within this.
Put my clothes back on or leave. So I'm.
The first place, get out of here. I'm like, no.
Because I was getting hot. No.
So the way that it's normally worked for up until this point is, an individual will be arrested and immediately taken to the Department of Corrections to serve out the sentence for that alleged conduct. However, with this system, there's a different way of doing things, an alternative route where a prosecutor for the state would be able to bring those charges prior to the serving of that sentence.
I'll ask the person right here. I'll ask the person.
Next question.
Ma'am, I put my clothes on and they're trying to arrest me for it.
Yo, what the f?
Please get this man out.
Only because he's black.
I put my clothes back on, like a good civilian.
And you are still causing a disturbance, so at this point in time, I will
Stop harassing black people. Come on, Americans.
Yeah, exactly.
Do they not know I'm black?
You're a bitch.
Man, we need to defund the police.
Man, shut up about that.
Next question, please.
I mean,
you are allowed to, oh, go ahead.
And why is what they have done to the person's reputation as well as job not considered during the trial as well? Like, you take into account the time spent in jail, but what about the time spent away from work? What about the time, what about the reputation that's now torn of someone who just wants to go back to MD?
We understand the potential issues that these things may bring. Of course, when it comes to the consequences that happen as a result of potential actions or otherwise, that's something that's more concerning with civil court, which again is still in the works, but is not currently ready for introduction in the state. But it is something that we are looking into in regards to perhaps introducing in the future. In regards to special training, we do have all of our attorneys going through their bar examination within the state. They will need to be certified in order to practice law, regardless of if they're in the prosecution division or the public defense division. When it comes to prosecutors specifically initiating cases, we do have the requirement of getting the sign off, the AOK from the Attorney General, who has been instructed to bring more scrutiny to ensure that there is no malicious prosecution. Private practice is still something that's being looked into. I cannot confirm that it will be introduced in the near future, but again, it's something that we're still looking into in regards to its feasibility and potential in the state. Like I said previously, for civil court, not quite ready to introduce that quite yet. We still have a number of regulations to handle in that regard, and preparation on the judicial branch side of things before we are able to introduce that. But it is something that we are hoping to have available. Again, I can't give a timeline on that, but it's something we are still looking into. if you want to go ahead, Daniel.
Oh, sure. The man over here in the jeans and the black rolled up shirt.
Just a quick question.
Oh yes, Tavares.
Apologies if I missed something and if this was already referenced, but I did not catch it if it was. So this opportunity for alternative prosecution, which will be offered rather than serving the sentence directly at the Department of Corrections, will it be open to all individuals, or will there be a consideration of the crime's seriousness? For example, a murderer will not be allowed to have it, but let's say someone that committed, let's say grand theft or minor sales tax evasion, or something that is not that major, will be able to get it.
No, I'm not sure I understand the question. So our prosecutors will be the one bringing the charges against an individual. We're still going to be having how we've had it similar to where if the police department places the charges and they spend their time in the Department of Corrections, they can then
She
bring
said
that
take
to the
the
court,
mask off or leave the area.
as usual. So if they feel like they've been wrongfully convicted and charged with a crime, they can still bring that to the Superior Court, like we've had it for about a year in the city at this point. This is for when the police department wishes to, or the sheriff's department wishes to take a different approach in terms of their prosecution and make sure the conviction is appropriate. They can bring that to our prosecutors to work with a case or cases that have been long strung out, but they cannot 100% without a reason but convict somebody. They can work with a prosecutor on that case and bring it to the court so the court can then decide if that person is guilty or not guilty.
And just to jump in here real quick, any charges will be able to be done using this option. Obviously, it's up to the prosecutor that's working on that case. You know, if it's worthy to bring it up with this system or not. But then also as a side note, you know, working with a prosecutor is not necessarily just a law enforcement thing. If any individual of San Andreas witnesses a crime and you know, would like to bring it up to the prosecutor, obviously, you know, your first step would might best be to go to the you know, Los Santos Police Department or the Los Santos County Sheriff's Department. But bringing up that information to one of our prosecutors is another option to begin the investigation as well.
Judy, would you like to take that question?
Sure. So yes, it's an alternative form of prosecution. So so the initial or the way that it's been working thus far has been you know, if law enforcement officers have probable cause to believe that a crime has been committed, they do have the opportunity to arrest that individual and place them in custody, as well as incarcerate them for those crimes, at which point you would be able to bring that case to the court system after serving your sentence. However, the alternative is now being able to go through the court system prior to the placing of charges. So it's just an alternative form of going through that system.
I do just want to remind everybody of this real quick, because it seems like some people maybe forget or something of the sort. So I'll go ahead and read this one paragraph of the press conference again. For context, the role of a prosecutor in a criminal trial is to argue on behalf of the state of San Andreas and must prove beyond a reasonable doubt that the defendant engaged in conduct that was in violation of the state of San Andreas' penal code. So basically what that means is if... is there a fight going on out in the street right now? Can we get somebody to handle that? Means is that the state or the prosecution must prove 100% beyond a reasonable doubt that these crimes were committed. This will prevent frivolous lawsuits from being filed, and or not lawsuits, but charges being filed against an individual to make sure that everything is fair within the state. What is happening in the street? Do we have any other questions? Yes. So just like previously, if a case goes all the way to an arraignment and the person pleads not guilty on those charges, just like usual, a case will happen on the docket. Discovery will be ordered from the prosecution. The case will be going just as we've had it in the past. If it goes all the way to a trial, those trials will be public. Along with the arraignments, they will be public but not advertised. So if members of the public do show up because they know an arraignment is happening, they will be allowed to participate in that arraignment. But trials, just like usual, unless anything is under seal, they will be happening publicly and will be advertised through the Weazel Entertainment News Network, just like usual. When it comes to a trial being public or private, that is up to the judge's discretion on the case. If they believe the information is sensitive and under seal, of course, something will be private. But in terms of everything else, it is up to the judge's discretion if they wish to make the trial or any hearings for that open to the public.
And just as a quick side note, our public trials are indeed first come, first serve. We do have a limited capacity. So if you are aware that a trial is happening, which we do have a list of when trials are happening that is updated once a trial gets scheduled, and that's under the judicial branch section. Essentially, it is first come, first serve. Whoever is in line there first will then get a seat until we are at capacity. In terms of Miss Valentine's question, of course, concerns about the publicity or having the trial private can be taken into consideration. The judge will likely ask both sides for their reasonings as to why this trial should remain private or public, but ultimately it is up to the judge's discretion whether or not that trial is public. The default, though, is public trials. So there would need to be a specific reason why the trial should be private.
All right. Well, if no other questions, then we're going to be wrapping up this press conference. I invite anybody who has any other questions they would like to ask in private to stay after. Me and Mason will stay around for a while. But that is going to wrap up the press conference in total. I appreciate everybody coming out here today and being a part of it and listening to the next step for the judicial branch. And once again, I appreciate everybody being here and the police department, the Department of Corrections, and the Weazel Entertainment News Network for being here today.